this program. So if you have any interest in it, I would be happy to speak about it. And I know that there are some MITS alumni in this room who can also speak about this program. So tonight, I'm going to be discussing about the proliferation of courts and tribunals, and I called it Navigating Multiple Proceedings. So first, I would like to thank Professor Nikos Lavranos and his colleagues of EFILA for inviting me. And I would like also to note that the topic is linked to research that Nikos Lavranos conducted a few years ago when not many people were interested in the field of the proliferation of courts and tribunals. So I went back to his writings and I thought, this is interesting. And we can discuss further about it in the Q&As. But tonight I will be concentrating on investment law and what it means to have a proliferation of proceedings. But so before setting sail and facing the sometimes turbulent waters of multiple proceedings arising from the multiplications of courts and tribunals, I think I would like first to recall you that plurality has always been intrinsic to the settlement of international disputes. So that's something that I think we need to recall ourselves before we discuss some few details and some rules. But in fact, if you go back to the 19th century when the judicial system or the dispute settlement system, I use system without a preconceived understanding of it, was designed, you had negotiation and then arbitration in the 19th century, so states could choose. And then in the early part of the 20th century, states decided to institute international judicial mechanisms. And with that, the plurality was strengthened. And that meant, and it's quite interesting to go back to the case law of the Permanent Court of International Justice, that meant that for the same dispute, or different aspects of the same dispute, in fact, you could have a few courts and tribunals who would be involved in the resolving of this dispute. So today, this phenomenon is even more important, and you find it in various areas of international law. I'm going to be speaking about investment law, but if you look at the field of human rights, you will see that, in fact, the parties are playing a lot this plurality of possible, and the possibility of having multiple proceedings dealing with the same issue or related issue. Why investment is important? Because you see signs of problems arising from this multiplication of proceedings. And I just want to take an example which is related to Brussels in a way. I'm thinking of the recent cases concerning the gas pipeline linking Russia to Germany via the Baltic Sea. What is interesting is that following the amendments of the gas directive by the European Commission, Nord Stream 2, a purposely established Swiss company, decided to initiate proceedings before the Court of Justice of the European Union. And in parallel, the company initiated other proceedings under the Energy Charter Treaty against the European Union, which is also something interesting. Then, what I think is important to note in the field of investment law is that international investment instruments often afford protection to both direct and indirect investors, so that several entities within the same corporate structure can be protected investors for the same investment. And consequently, each entity in the chain may potentially seek to challenge the same measures taken by the host state and claim compensation for the same damage. So needless to remind you and to recall you the saga of the Lauder versus Czech Republic and the CMA versus Czech Republic cases, because all these issues were discussed. But more recently, we've had also cases involving a company, Orascom TMT, and Orascom Telecom, and they were both companies which were linked, part of the same corporation structure, were in fact launched disputes against Algeria and involving the same measures that were taken by Algeria. So that, I think, is something that is important to take into account. In the field of investment law, there is also this aspect of you can have parallel proceedings before international tribunals and domestic tribunals. And this is, I think, a specificity of investments. And there, in this context, you can have parallel proceedings going before domestic jurisdictions and international tribunals. That is also not something very new. I'm thinking of doing this research for this conference. I'm thinking of a case which was brought before the Franco-Bulgarian Mixed Arbitral Tribunal in 1922, when it received a request either to delay criminal proceedings pending before a Bulgarian court or to stay the proceedings before it. So the questions that we're dealing with, in fact, were already questions that some courts and tribunals faced. So this issue of concurrent proceedings before international and domestic proceedings can be observed in some other areas of international law, but as I've said, in investment law, there is more potentiality for these parallel proceedings. And why is it so? And why I think we should look at that and have it in mind. First of all, you have this distinction and not distinction between contract claims and treaty claims. Okay? And when you think about contract claims, you sometimes have jurisdictional provisions referring to domestic courts. At the same time, you have an investment treaty which is providing for international arbitration. So you might have competing jurisdictional clauses that may be triggered with respect to the same or related issues. Then if you look more closely at investment treaties, you're also going to note that very often there is a reference to domestic courts, either as an alternative to international jurisdiction or as a preliminary remedy, and you have a certain period of time that you have to respect, and so on. So that might also create problems of parallel proceedings. And then I think it's also something to be noted is that it is increasingly frequent that for a state to claim that the investment has been tainted with some form of illegality. And in response to this alleged illegality, the state might have initiated criminal proceedings against the investor or a number of related third parties. And so when you're going to have an arbitral tribunal set up, the proceedings are not going to be suspended. So there is an issue of the relationship between the ongoing domestic proceedings and the arbitral proceedings. So that is what these various scenarios are the issue I'd like to deal with. I called my conference the multiplication or the navigating the multiplicity of proceedings. It's not a speech against the multiplicity of proceedings. It's more the fact that there might be some risk arising from multiple proceedings. So one of them, and one of these risks is conflicting decisions. And I think that there are different discussions about conflicting decisions, but it's not really good for a system as such. But there are other risks associated with parallel proceedings. You can think about the costs which are involved in the abusive duplication of proceedings, and costs in the field of investment are becoming more and more important, so I think it should be a concern. Then there might be also an issue of integrity of the proceedings which are conducted. So in order to take into account this risk and to face this risk, I thought that it would be interesting to think about the tools that we have at hand for facing the risk associated with the multiple proceedings that can appear. So, in order to think about how to face this situation, I thought that one way of looking at it is to think, shouldn't we have a coordinated disputes resolution process? But how to coordinate this dispute resolution process? This is the question that I would like to deal with you, to speak about tonight. When I think about this issue, I think about two intervention times. the first intervention time is that when there is a referral to courts or to a tribunal. I will use court also involving tribunals. So the time when a case is brought, there is a referral to a court. There might be things that can be done for preventing multiple proceedings. Then there is also the time of intervention is when, in fact, all these multiple proceedings are going on. So what should be done in order to face the risk that might arise from this situation? So let me now start with the first intervention time. And this is going to be choosing, at the moment of choosing a forum ab initio. So there, it's interesting, and I must say that I've been quite amazed by the richness of the tools that you can now find in the instruments which are negotiated by the European Union. So I'm going to be referring to some of them. So the tools that I'm going to be looking at first now, it's when, in fact, there is a choice to be made. You want to bring a case before a dispute resolution mechanism. So there, in this context, we have different tools, and I've named them, and it's the most important one is the fork in the road. But I'd like to refer to one that I found in a treaty, which is that, in fact, you have also the possibility of having started proceedings, and then you decide you don't want anymore to proceed with these proceedings, so you're going to put an end to them, and there the treaty says you can thus start another proceedings before another tribunal. So you would need to have an explicit provision about that. But otherwise, the tools that are going to be looked at the moment of the ab initio time, it's the fork in the road provision. Fork in the road provisions, this is an interesting one, and once it's a choice, it's an option which is expressed as the right to choose between different jurisdictional systems. So in the context of arbitration, we're there before, we have the choice before domestic, of bringing a case before domestic courts or before an international tribunal. Now, yes, so we have the fork in the road. The problem is that when you look at the fork in the road provisions more carefully, what you're going to see is that there is what we call, I'm going to speak often about it, a threefold identity test, which has to be made, to be met. So, as I'm going to quote a tribunal, namely for fork in the road to play a role, a claim with the same object, the parties, and cause of action, you have to have a situation where a claim with the same object, parties, and cause of action is already brought before a different judicial forum. So for applying these conditions, you're going to have to identify who are the parties, what is the cause of action, and what is the object of the dispute. And when you look at the practice, you're going to see that the tribunals have had a very strict interpretation of these three criteria. And that, in a way, the question that I had, and maybe we can come back to that, is that isn't it time to soften these conditions? Mm-hmm. Isn't it time, in fact, to be looking more at the economic reality of the investor or the investors which are involved in the different cases, and also maybe also looking more carefully at the basis of the claim, so that we understand better how the fork in the road provision can play. Now, what I think is interesting with the fork in the road provision is that you have had an evolution in terms of the refinement of the content of these provisions. And there, what I think is interesting is to note that there is a second generation of treaties that has added the obligation for the foreign investors and any local operating company to waive the right to submit or continue the same dispute elsewhere. And this is the case of NAFTA, for example, and it's also the case of the subsequent treaty which might enter into force one day which will replace NAFTA. A third generation of treaties, and that is this generation of treaties are concluded by the European Union. It's interesting because there, the European Union, when it speaks about the fork in the road provision, extend the prohibition on parallel claims to direct and indirect shareholders, where the loss, and they consider that the loss suffered is the same. So for looking at, for example, such a provision, you can look at the EU-Mexico Modernized Global Agreement, which has specified the rule that should be followed. Now, as we see, there is a growing awareness, and maybe that the refinement that I've mentioned are not sufficient, and maybe there is space for thinking a bit more about all that. There is also the other technique, electra via. Electra via is more, in fact, I think it's not really very different from the fork in the road provision, but it's mostly used when there is a choice between two international procedures. And we find it in the context of trade. And think about Article 2005 of NAFTA with the possible choice between NAFTA procedures or the WTO. In the context of investment, it's interesting to see that for the time being there is not much practice, and maybe this is also something that states could think about when they are negotiating the treaties. Associated with fork in the road and electra via, there is another rule, which is a specific rule, which is linked to the Washington Convention, the ICSID Convention, and it's Article 26 of the Washington Convention, which says, I'm going to remind you, consent of the parties to arbitration under this convention shall, unless otherwise stated, be deemed consent to such arbitration to the exclusion of any other remedy. This is a well-known rule, and in fact it's a rule that tribunals have often referred to when they want to say you have to choose either it's domestic jurisdiction or it's our tribunal, but in the context of ICSID we have the privilege and we should be the one to decide about the case. Now, what is interesting, and looking back at the travaux préparatoires and looking at the writings of Christoph Schroeder, it's interesting that at the time of the drafting of Article 26, they were already thinking that Article 26 could also be used when you have two international proceedings going on. And there has been an example which has applied this rule, which is AMPAL, American versus Egypt, where the tribunal found that, in fact, there were two claims, the same claims in two arbitral proceedings, two different arbitral proceedings, and then it asked, the tribunal offered the claimant the possibility to elect the forum where it wished to pursue its claims, which it did within the prescribed time limit. So there, Article 26 was used by the tribunal to say you have to choose where you want to bring this claim. So as you can see, there are some rules that can be referred to when there is the choice should be made about which forum, before which forum the dispute should be brought. Now, it might be that there are not such rules or no choice have been made and so on. So we're going now to move to the further step, the further stage when in fact the proceedings might go on. And there we're going to wonder, so what can a tribunal do, in fact, if you have risk associated with multiple proceedings? So with that, it's the first situation that I'm going to refer to, and the question that I think is that there I think we can think about the principle of good faith. So I know that I'm more a public international lawyer, and that public international lawyers are always obsessed with the principle of good faith, but I think it's a principle which finds application in all legal systems, and it has some value. So what does the principle of good faith mean in the context of these multiple proceedings? I think that first it is important for a court or a tribunal to establish whether the referral is in good faith or simply serves as a pretext to evade obligations and frustrates the rights of the other party. And in various forms, these bona fide requirements can provide a means for sanctioning a party which is abusing the multitude of options it has at its disposal. So we have a few cases. I'm just going to quote one case, the Transglobal Green Energy case against Panama, where the tribunal upheld Panama's objection to jurisdiction, I quote, on the ground of abuse by claimants of the investment treaty system by attempting to create artificial international jurisdiction over a pre-existing domestic dispute. Mm-hmm. So that would be an application, a possible application of the good faith. Now, another application maybe is estoppel. It's estoppel when, if you could dig in the practice and realize that in fact the claimant had made the commitment that it would not go to international arbitration. I didn't find any practice, but it's interesting that estoppel has been pleaded before has been pleaded in the context of the WTO and in relation to a Mercosur proceeding which had taken place. So, good faith, estoppel. Another facet of the good faith that can, I think, also be referred to is in the case when you have frivolous frivolous claims, and the tribunal is going to try to say that the claim is frivolous. So the tribunal might argue on the basis of the principle of good faith. And it's interesting to look at the treaties negotiated by the European Union. I'm referring to CETA, but in fact, if you look at all the treaties, you're going to have the same provisions. CETA in Article 8.3, when the rule says that the tribunal is able to dismiss at the outset a claim that is manifestly without legal merit. So it's going to be an important power for the tribunal to decide that the claim is without legal merit, and I think it's one of the manifestations of the principle of good faith. Now, when you don't have a provision like this one, which is enshrined in the EU investment treaties, question that maybe we can discuss further on is that, do you think that the tribunal has the power to decide it? And there I looked at what Sir Gerald Fitzmaurice had written about the International Court, and Sir Fitzmaurice at that point, at some point had said, but there should be a filter somewhere. So he considered that the court should have this right of deciding, of dismissing at the outset a claim when it's frivolous. Question, is it possible for investment tribunals? Now, another expression, I think, of the good faith principle is manifested through the inclusion of anti-circumvention clauses. So these clauses, what they are intended to prevent an investor from bringing a claim when she has acquired an investment for the sole purpose of being protected under the treaty. And there, if you're interested in such a rule, you can look at Article 16 of the EU-Mexico Modernized Global Agreement, which has established that the tribunal shall decline jurisdiction if the dispute existed or was highly foreseeable at the time the claimant acquired the investment, and the main purpose of this acquisition was to submit a claim. Mm-hmm. So that would be another manifestation. Now, if you don't have a provision on anti-circumvention, well, can you use another device of international law? And I think that abuse of rights is also a notion that we should be thinking about. And I think abuse of rights and good faith are associated. So there, when you speak of abuse of right, the tribunal would be looking at if there is an abusive manipulation of the system of international investment protection. And it's interesting because there too we have a case. We have a case where tribunal referred to the abuse of right, and it was in the case that I mentioned earlier, the Orascom TMT versus Algeria case. And in this case, as a reminder, the tribunal was confronted with a claimant who had invoked the protection offered by Algeria's various bilateral investment treaties at various levels of the corporate claim. And the tribunal concluded that such conduct constituted, and I'm going to quote the tribunal, an abuse of the investment protection system, and consequently it declared that the claim was not admissible. So that is also another manifestation of the notion of good faith. Now, so that's the first situation. We can look at another situation where there are parallel proceedings going on. Are there any ways for a tribunal or the two tribunals to be taking into account these parallel proceedings? And there I'm going to refer to known principles to all of you. It's the res judicata principle and the lis pendens principle. I think there they have virtues, these principles, and we all say that they are principles of general principles applicable in domestic law, in transnational law, and at the international level. And what is at stake is the finality and the certainty. So we're sure that it can't be brought again before another tribunal. Now, what is interesting is that the application of the res judicata principle in the field of investment is not common at all. You have a few cases, but they are rare, these cases. And why is it so that, in fact, res judicata is not really used in the field of investment? Once more, we're facing the triple identity test and the difficulty of meeting the conditions set by this identity test. And remember the Lauder versus Czech Republic case and the CMA versus Czech Republic cases. In these two, before these two tribunals, the argument of res judicata was made, but they had a very formalistic understanding of the principle. And so it was not accepted. There too, I think that the formalistic interpretation appears to be inadequate in our contemporary world. And it seems to me that having a formalistic interpretation of the res judicata in the field of investment, in fact, plays into the plaintiff's litigation strategies. And there is, I think, some thought to be given to how to understand and interpret the res judicata principle. As I call it, I think we should have a more relaxed interpretation of this principle. And one of them, I think, is in relation to the fact that with respect to the identity of the parties, that's the big issue. And there it seems to me that we should borrow from another English notion, which is the notion of privity. Okay? The notion of privity, you could conclude that the identity of the parties would include the parties with which they stand in privity. So that is a notion that has to be explored a bit more. It was used in one investment arbitration, the Apotex versus United States case, where in fact the tribunal used this notion for saying that, for underlying the equivalence in the parties in two cases. Now, res judicata are difficult and need to think further about it. What about lis pendens? What about lis pendens? Do we have, there are more potentialities with lis pendens? And there too, lis pendens, you need the three elements. So once more, we're confronted with the fact that you need that the parties are the same, the cause of action is identical, and the object of the dispute must coincide. And so, like with res judicata, it's almost impossible to implement it in the field of investment. And it's interesting to see that the tribunals have been sort of pushing it away very easily without justifying the reasons for pushing it. There is, and I'm just referring to one case which is interesting because it did enter, it did give a more detail. It's the Benvenuti and Bonfant versus Congo case, where it explained why, in fact, these pendants could not be retained. So there too, I think that there is a need to think about the triple identity test. There is a need to think a bit more about it. And there, I think that really, with respect to these pendants, there is a need to think about the economic reality and the fact that shareholders and companies should not be able to have distinct claims before two tribunals, and there may be that some thinking could be given to the test of these pendants and you have some signs of agreements in some words, but you don't have yet a clear answer. And it's quite interesting because what I'm thinking for investment law is the same in international law. And there is a current case before the International Court of Justice where there is, to my mind, an issue of these pendants, but I think it's going to be very difficult to establish it because of the strictness of the criteria as defined in domestic law. But don't you think that you need to think in other terms when you're transplanting these principles at the international level? So, one other word about these pendants. Remember I said one of the tests, one of the elements of the test is the identity of the cause of action. And in the trade field, more and more, the trade agreements are speaking of a substantially equivalent cause. And I wonder if we should not have also this criteria for investment, substantially equivalent, which would not be identical. So that's another issue that we can explore further. So, as you've seen, not much success with these two principles, potentialities, but need for thinking about how to make them applicable in the field of investment law. Now, third step, it's so if we don't have the good faith tools at disposal, if we can't refer to the two principles of res judicata or its pendants, is there not an issue about the fact that the tribunals have to play a role in the international dispute system? And this active cooperation, as I have named it, would be relying on the judges or the arbitrators' awareness of their place in the jurisdictional fabric and the awareness that there is a need for coordination and cooperation. So what do we mean by that? We mean by that in a way there is something to be done because in fact there will be an incidence, an impact of one proceedings on the other one, but we don't have the tools that I mentioned at disposal. So one first way for the tribunal would be to act on the basis of committee, and that would be that it's discretionary. There is no obligation for the tribunal, but the tribunal would say, I act on the basis of the principle of committee because it appears that the proceedings before another court, and what I'm doing might have an impact on the resolution of the claim. So needless to remind you in this room that this looks very much like the Mox-Planck case, and you all have in mind the saying of the tribunal in this case. Interestingly, it was pleaded before investment tribunals, and I'm only going to refer to the Errico versus Slovak Republic, where it was pleaded. And what is interesting for me in the context of this word is that the tribunal said that there were proceedings before the European Court, and there were proceedings going on in the context of an investment tribunal. The tribunal said, that the impact would be minimal. Looking at the proceedings before the court, the European Court, it said it would be minimal. So it said, I'm not going to decide on the basis of committee. But it said also that it was prepared to reconsider the question should the situation change. So it's quite an interesting award where the tribunal said that yes, I can have a role to play on the basis of committee. Now, committee, as I said, is discretionary. But what is interesting is that if you look at Article 8.24 of CETA, you will see that there, in fact, the treaty has removed the discretionary nature of the consideration of committee. In all the European Union treaties negotiated with the various actors, there is no more discretion because, in fact, Article 8.24 is saying, should another claim have a significant impact on the settlement of the CETA claim, then the tribunal must stay these proceedings or ensure that the other proceedings is considered in its decision. Okay. So that it's an explicit formulation of the notion of committee in legal terms. Now, so we have committee. Maybe that's now civil law which is coming. In the French system, we have the notion of connexity. And I've always wondered if connexity should not play a role at the international level. So connexity, we know more with the identity of the claims, where we are with related claims, which can have an impact on each other. And in the French legal system, this is a rule which is admitted, and preparing this lecture, I was wondering if it's not, in fact, a rule that could be an expression of the principle of committee and would give more teeth to the principle of committee. Now, last point about this active cooperation. Even if you have multiple proceedings, you can't do anything about these multiple proceedings. Maybe there is a way for the tribunal to take into account what's going on before the other tribunal. So that could take the form of deciding about certain deadlines, so that you would wait maybe a bit of and give some time to the parties to express their viewpoints in the context of other proceedings. There is also the issue of access to the documents. So very often you have issues of confidentiality which are at stake, but maybe that one tribunal could accept to levy the confidentiality requirement, so that the other tribunal could have access to the pleadings and understand better what is going on with the two parallel proceedings. So with that, I have mentioned a few issues. There is another technique that I would like to mention, which is consolidation. Consolidation is something that is known before the International Court of Justice or in other area. It's interesting to see that in investment law for a long time nobody was speaking about consolidation of cases. And it's interesting to note that in the context of exits, there is no mention of the rule of consolidation. Now, what is interesting is that the recent treaties are all now referring to consolidation. But the problem is the fact that when you speak about consolidation, you need to think about the connection. And it's sometimes difficult. But there is also another issue, that when you're going to have multiple proceedings, it might be that you have proceedings before exit, another one in the context of ancestral before the PCA. Okay? So two arbitral institutions are involved. And there is something to be thinking about what I call cross-institution consolidation, because I think that time also has come to think about these links. And looking at the sources, I looked at the Singapore International Arbitration Center activities, and they have proposed in 2017 a protocol permitting the cross-institution consolidation of arbitral proceedings subject to different institutional arbitral rules. This is in the context of commercial arbitration. And I also noted a speech gave by the current president of the ICC, Alexis Moore, where he said that we should be working on this, on rules allowing for the consolidation of arbitrations initiated under different auspices. So maybe time has come also to be thinking about that for investment proceedings. So with that, I have given you an idea of what are the tools, what can a tribunal do. The question, if we use the metaphor, is that if we have been able to apply all these rules, maybe we're in calm waters, okay? And there is the system is coordinated. But the question is, but what is the energy that should be used for making these boats to move? And there are, in fact, questions, and I think for the negotiators it's very important, is that in some treaties you see that you have specific provisions which allow the tribunal to use one of the tools that I have mentioned. Okay, so there I think that when it's expressly mentioned, there's not much difficulty for the tribunal to take a position. But quite often you don't have this explicit provision. So on which basis could the tribunal decide that there are risks that I should confront? Compétence de la compétence. I think that's an interesting principle that has not been fully explored in arbitration. Compétence de la compétence, it functions for jurisdiction. It also functions for admissibility. So maybe at the time of admissibility, when you start, you could decide that there is a problem. But maybe also there is another interpretation of the principle of compétence de la compétence, and there it would be for the tribunal to decide that, putting aside jurisdiction, putting aside admissibility, there might be certain circumstances where it is desirable not to exercise jurisdiction at a given time or to adjourn proceedings because there is a problem. Okay? So compétence de la compétence would be a principle which is a principle of international law which would empower the tribunal to decide about how to organize the proceedings. The other basis that I think is important is the inherent powers doctrine. Inherent powers, you have at least reference to these powers in the exit convention. But sometimes you don't have reference to these powers. And so what to do? And there I looked at the case law of the International Court of Justice. And it's interesting to see that, or to other courts, these courts have been explaining that inherent powers are very important for safeguarding the sound administration of justice. Okay, so the good management of justice is associated very often to the notion of exercising inherent powers by a court or a tribunal. And it is also said by the court that inherent powers is also a means for safeguarding the basic judicial function of a tribunal or a court. So should we go too far when we say that maybe it would be good that tribunals are reminded of their functions in terms of maintaining and ensuring the sound administration of justice? It's also a question mark. So we are reaching the end of this trip. And what I'd like to mention is that what I have said, it's mostly looking at what courts and tribunals can do. I've also referred to states as legislators, okay? States when they are negotiating investment treaties. And what I've stressed is that they have tools for managing multiple proceedings. But in fact, there is one actor I've not referred to, and I think it's important to remind the importance of this actor at the end of this lecture. It's the parties. The parties are key in ensuring a sound administration of justice. I feel that international justice is an important public good for all of us, and we should protect it as much as we can. And so what I think is that the parties are instrumental in preventing multiple proceedings which have negative consequences or for negative objectives. They are the ones to choose to resort to several courts or tribunals. They are the ones who can anticipate the problems which might arise. And in concluding this lecture, I would say that there too the parties should act in good faith when they're resorting to international arbitration. Thank you very much.